Hey everyone, it's David Sirota. So by now you've probably heard that Equifax, the credit reporting agency, has potentially exposed up to 143 million people's data, their personal data, to hackers. On Friday, a story broke about how the company includes fine print language on its website that may attempt to force you to waive your legal rights to sue the company if you were a victim. Now, the company has since said that it is not applying this language to the current situation, but it's an important cautionary tale. The company includes fine print a so-called arbitration clause, which basically says that in order to use its services, you have to agree to waive your rights to go into court or be part of a class action lawsuit. So a bunch of folks on social media started raising the question, well, Equifax is now saying that you can go on its website and check to see if you were a victim of this data breach. Does that mean in order to check to see if you're a victim, does that mean by doing that you're waiving your rights to sue the company? Now, the company has since said, again, it's not going to apply this particular clause to folks who simply check to see if their data was breached. But there's an important public policy context to this. These kinds of arbitration clauses, the Consumer Financial Protection Bureau is trying to basically outlaw them. There was a rule that was proposed under the Obama administration by the CFPB, which would say that companies cannot force their customers, or really anyone else, to agree to waive their legal rights as a contingent of doing business with them. The CFPB was aiming to outlaw these kinds of contracts, these kinds of provisions. Equifax's lobbying group in Washington was lobbying essentially to weaken or kill that rule. So this is an important set of contexts here for what happened with Equifax, because credit reporting agencies are often at the center of these kinds of class actions in which companies are accused of violating people's basic rights, and then they include these arbitration clauses to try to prevent people from essentially from suing them. Listen to this. So in one letter that Equifax's lobbying group sent to regulators in trying to weaken this rule, the group declares that regulators, quote, should exempt from its arbitration rule class action claims against providers of credit monitoring products. The letter asserted that allowing customers to sue companies, quote, would not serve the public interest or the public good because it could subject the companies to, quote, extraordinary and draconian civil liability provisions under current law. So basically, Equifax, its lobbying group, on behalf of Equifax and other companies like it, don't want people to be able to sue companies when situations like this happens. Now, also, concurrently to this, Equifax's lobbying group was also last week, the same week that this data breach was reported, Equifax's lobbying group was supporting a bill designed to cap the amount of damages that a jury can award victims of things like data breaches when they bring class actions. In the same week, Equifax's lobbying group was supporting that Republican-backed legislation in the same week that it announced that data breach. The CFPB rule is now moving forward, but congressional Republicans are trying to kill that rule, basically trying to help businesses kill the rule so that businesses can continue to put in these fine print clauses that force customers to waive their legal rights. It's a fight that's still going on. Congressional Republicans hope to use their power to pass legislation to essentially repeal the Obama-era rule. Keep your eye on that CFPB rule. It's a rule backed by Senator Elizabeth Warren. It's been something that she has championed. It's a hugely important rule, but the Republicans are trying to challenge it, and the Equifax situation shows, many people believe, why the rule needs to be in effect in the first place.